the first case on this afternoon's docket, and that is case number 128438 from Johnson County. Michael Szerwinski. Well, I was closer than I would hope. Szerwinski, appellant versus the Mainstreet Associates, Inc., doing business as Minsky's Pizza Appellee. Would the parties please state their appearances?
Please the court, Jonathan Sternberg for the appellant.
May it please the court and good afternoon, Your Honor. Jackson Wagner on behalf of the appellee, Ms. Pizza.
All right, and Mr. Sternberg, would you like to reserve any time for rebuttal?
3 minutes for rebuttal, please.
3 minutes are granted. And with that, you may proceed.
Television in front of me. May it please the court. I'm Jonathan Sternberg and I represent the appellant Michael Szerwinski. Diving right in, I want to be clear that this appeal presents what is really a narrow question. And I would like to ensure the court understands what we are and are not asking Your Honors to decide. We are not challenging the dismissal of Mr. Szerwinski's respondeat superior claim in count 1. And we are not disputing that the employee who was released in the release that we're going to talk about was fully released. Rather, the only issue in this appeal is that, as the Kansas Supreme Court made clear in the Luther case in 2000, a general release of one party that doesn't name or specifically identify a different party doesn't extinguish a claim for independent negligence against that other party. As in the Luther case, the district court here violated this principle in dismissing my client's independent negligence claim against Minsky's, and this court should reverse. Now, it does also matter that this case was decided on a motion for judgment on the pleadings. Every factual allegation in that petition, in my client's petition, has to be taken as true, and all inferences have to be drawn in his favor. To prevail, the defendant has to show that viewed that way, on the face of the pleadings, viewing them that way, it gets judgment as a matter of law. Minsky's didn't meet that burden because Kansas follows the specific identity rule, which the Supreme Court adopted in Luther. Under that rule, when a plaintiff alleges independent negligence against a tortfeasor, a release extinguishes the defendant's liability only if the defendant is named or specifically identified in some other way in the instrument. Broad boilerplate language about all claims arising out of the accident or the like isn't enough. And in Luther itself, even saying all other persons, firms, corporations wasn't enough. Well, here, in what is essentially a repeat of Luther, nothing in the release of Mr. Crocker, who was the driver, specifically identifies Minsky's. Now, I know Your Honor said that you're very familiar with the facts, but—
One thing before you go into the facts.
Sure.
Since this is a motion for judgment on the pleadings, is there any problem with looking at that release, which is a written instrument attached to the answer?
So this was an issue that we could have appealed, I think, if we desired. I know that my trial counsel made this argument in the trial court, that this really should have been viewed as a summary judgment motion, not a motion for judgment on the pleadings. But if I had appealed that issue and we were successful on that, all we would get out of it is a remand to the district court to reconsider this as a motion for summary judgment. We wouldn't get to, I think, the ultimate issue in the case, which is what we want to get you to here today. The way I read the law of Kansas, and I don't think my opponent disputes this point, that's something that we would have had to appeal, that we would have, and by not appealing it, we are conceding that issue. So no, I don't think that's a problem. We are willing to treat this as a motion for judgment on the pleadings. I don't have a problem with that at all. And I thank Your Honor for asking me that. But because—
Clarify one fact for me.
Yes, Your Honor.
So I think the driver, his name was Crocker.
Yes.
This release occurred under the personal policy of that driver, not a Minsky's policy. Is that correct?
That is correct. Okay. Yes, Your Honor. It names him, and I think it's his wife, might be his mother. I'm not quite sure. I think we said wife, but it's him and his wife, and names Allstate, and it's their personal policy. It has nothing to do with Minsky's at all. That's correct. So my client, Mr. Szerwinski, is injured in a bicycle collision with the Minsky's driver, Mr. Crocker. He later settles with the driver and the driver's insurer for $100,000. The release, and this is before any lawsuits filed or anything like that, pre-litigation, I think they call it. The release identifies by name the driver and this other person. It identifies by policy number and claim number Allstate. It releases those parties with respect to the insured claim. What the release doesn't do, and this is the crux of the case here, is name Minsky's. Not just that, but it doesn't describe Minsky's. It doesn't refer to employers or principals or corporations or delivery companies or businesses.
When you're naming the other people it doesn't describe, the rule isn't just that it has to specifically name the person. This is actually a rebuttable presumption, right?
That is correct, yes. It is a rebuttable presumption, and that's where the fact that this is a motion for judgment on the pleadings is key. That if we are going to engage in a rebuttable presumption, well, we have to view, at least at this stage, we have to view the facts and the inferences in a light most favorable to my client. And Minsky's doesn't do that. In fact, in their brief, they seem to suggest that, well, based on the language in this itself, in the release itself, that rebuts the presumption. And I don't really see how they get there. But it is a rebuttable presumption. I don't have any Kansas cases, and I don't think the other side cited any either in which that presumption was held to be rebutted ever.
How would that work in a motion for judgment on the pleadings anyway? Like, how would one rebut a presumption by way of the pleadings themselves?
I don't think you could. I think that's, I mean, I suppose if in the pleading there was a concession, right, that said, we also released, Minsky's while releasing the driver, obviously that would have to be taken as true. But unless you got to that, I don't see how you'd get that in a motion for judgment on the pleadings. Most of the cases that we cite, I think almost all of them, except for the Wright case, are dismissals rather than judgment on the pleadings. And Wright from 2001 is a summary judgment. So either way, though, even in summary judgment, the evidence would have to be viewed in a light most favorable to the non-movement. And I think that's where they got to that too. Well, in Luther, the Supreme Court rejected what they called the flat bar rule that treated language about all other persons, which is what Minsky's relies on here. Minsky's relies on language in this release that says we're releasing all claims arising out of the accident. Now, there's a connector before that in the release that says, as to these parties who we're releasing, but getting beyond that, if you would just take that language, in Luther, the Supreme Court rejected using language like that as dispositive and adopted this specific identity rule. The court there held that this rule applies even where the release language is sweeping, which it was far more sweeping, as I already said, than it is here. The plaintiff was represented by counsel. One of my opposing counsel's arguments in their brief is that, well, we were represented by counsel, so we should be held to a higher burden. In Luther, they were represented by counsel too, and the claims arise from a single accident. The same thing there's joint tortfeasors. Now, they seem to suggest in their brief that they don't really qualify as joint tortfeasors in the same way because we're talking about an independent negligence claim. If your honors remember from law school, there's I don't remember exactly what the context was, but there's it's concurrent proximate causes where you have two fires that are going up a mountain. Nobody, different people caused each fire. They're still independently responsible for the ultimate injury. Well, here, if in our count two, we alleged that Minsky is engaged in negligent hiring, retention, et cetera, supervision of this driver, that's still an independent claim of negligence. And again, pretty much exactly the same in Luther. It's striking if you read my opponent's brief, they really never grapple with Luther. They acknowledge at one point that Luther does state the current Kansas law on this and that Kansas courts do apply the specific identity rule. But then they go on and try to use a case that's 8 years before Luther that applies the flat bar rule. It's White from 1992. It's an unpublished decision. In fact, it's so unpublished, it's not even in Westlaw. I'm thankful that we have the rule in Kansas that requires people to attach unpublished opinions to their briefs. Otherwise, I don't have Lexis. I wouldn't have been able to find it. But the point is in White, which is what they gave to the district court, and the district court cites in its decision too, not only does it predate Luther and apply this flat bar rule using broader language, the release there expressly discharged, quote, all other persons, firms, and corporations. This release doesn't do anything like that either. But so what happened here is almost exactly the same thing that happened in Luther. And we're asking the court essentially to do the same thing the Supreme Court did in Luther, which is reverse effectively an identical order, except there as a dismissal rather than a judgment on the pleadings. And all the other decisions that Luther relied on or that came after Luther concur with this. We cite the Geyer case, which first applied the specific identity rule in Kansas in 1979. The Supreme Court approved of that in Luther. This court reversed a dismissal of an independent negligence claim there, where the release named one tortfeasor, but not the other. Effectively the same thing here. The Wright case I already mentioned, which was a summary judgment. That's where you had a newspaper who was released, but not the individual people who wrote in the newspaper doing the alleged defamation. That was held to be an independent negligence claim. That still survived the release. And in the Mulroy case, which they try to rely on it, but I think it's actually far more in our favor. Mulroy's in 2001. There you had an employer and an employee. And one of the claims that was at issue was a respondeat superior claim, but there also was a question of whether the tortfeasor was, the employer was independently negligent. And this court applied the specific identity rule even in that context, emphasized that independent negligence claims stand on their own, even when an employee is released. The overarching principle of Kansas law is consistent. If the defendant isn't specifically identified, the release doesn't apply as a rebuttable presumption. Minsky's only arguments against this fail. They cite these two cases, White and Davis. I mentioned White already. Davis involved only respondeat superior liability, expressly declining to apply the specific identity rule because the employer's liability there was purely derivative. Frankly, Your Honors, the reason we're not appealing the respondeat superior liability issue is because of cases like Davis that I think that clearly is barred by this release, but we're not here on that.
Can you help me understand the concurrent versus successive tortfeasor argument that is being made, here by Minsky's? Do you understand what that's about?
They seem to mention this in passing in their brief, and I grant we didn't address it a lot in our reply brief. I think what they're saying is that if they were negligent, it happened before the driver's negligence that was being released, and somehow that extinguishes their liability. First of all, that's not an argument that I think they made below, and I don't see how that would apply here. Anyway, the question is, are they joint tortfeasors? Would either of these claims, and this is a standard form of personal injury action, right? Where you see a claim against an employee and a claim against an employer, not just for vicarious liability, but also for independent negligence. If we can show at trial, as we've alleged, taking our facts as true in our brief, or sorry, in our petition, that Minsky's engaged in negligent hiring, supervision, retention of this employee, and that caused my client's injury, they're still a joint tortfeasor. I don't think the order of when it happens matters, and I don't think any of the case law says the order of when it happens matters either. Minsky is asking this court to do what the Supreme Court forbade in Luther, to allow boilerplate language to extinguish an independent negligence claim. That's simply not the law of Kansas. The release of the driver doesn't affect my client's independent claims against Minsky's, and we ask this court to reverse.
Thank you.
Thank you, Your Honors.
Any other questions from the panel? No. All right. Thank you.
Good afternoon. May it please the court. Jackson Wagner on behalf of the appellee and defendant Minsky's Pizza. Your Honors, in this case, in this context, under this specific set of facts, I believe that Judge Haber was correct. Similar to my opponent, I'm not here to advocate for a move away from the specific identity rule as announced in Luther. For all intents and purposes, I think the logic behind the specific identity rule is sound. There should be some safeguards in place which protect unwary, inexperienced, unwitting plaintiffs from releasing claims that they otherwise could have had. I am here today to advocate that Judge Haber's order granting Minsky's motion for judgment on the pleadings was correct. As stated by my opponent, the sole issue to be determined on appeal is whether plaintiff's claim against Minsky's for negligent hiring and retention of their delivery driver were released in the release of all claims, which was drafted by plaintiff's counsel and executed by the plaintiff.
Counsel, could you, and I've got it in front of me, the language of that release. Could you point me to the specific language that releases Minsky's?
Yes, Your Honor. As determined by Judge Haber, if we read the first paragraph and the fourth paragraph in tandem, I think the language contained in those two paragraphs is sufficient to release Minsky's.
Where specifically within that?
Yes, Your Honor. The Language states in paragraph 1 that Minsky's employee, his heirs, executors, administrators were released from all causes of action arising from any act or occurrence, and particularly on account of all personal injury or damages of any kind sustained as a consequence of the September 2022 accident. And then in paragraph 4, plaintiff affirms that the release of all claims, that the $100,000 which he received was made to terminate further controversy respecting all claims for damages that he had asserted or that he or his personal representatives could hereafter assert because of the crash. Judge Haber, in his learned experience based on the oral arguments in the briefing we submitted, agreed that that language was sufficient even under the specific identity rule.
And where in that language does it specifically identify Minsky's with a negligent hiring claim?
Your Honor, I fully concede that it never states in there, and we hereby release Minsky's. It's our.
Is there a reference to a claim against Minsky's in here?
Your Honor, there is no explicit reference to an employer or to the negligent hiring, retention, entrustment, or vicarious liability claims against Minsky's explicitly. It's our position as determined by Judge Haber that when we read paragraphs 1 and 4 in tandem, that it's sufficient to encompass any claims that could have arisen out of the crash. Now, the only two defendants that there possibly could have been resulting from this crash were the delivery driver and his employer, Minsky's Pizza. And so
That's not true. Could probably sue the car manufacturer, the bicycle manufacturer, the helmet manufacturer. There's a continual reference here to the judge's learned decision, et cetera, in making this. Is it your contention that we're obligated to give some deference to that
no, Your
in
Honor,
this review?
No, I understand this is a de novo review. It's not a review for clear error. It's completely a de novo review. But Judge Haber has been on the bench for a long time. I think he's a very good judge. And so while his opinion's not necessarily entitled to any deference, and I don't say that to mean that any of you, that he's smarter than anybody else or anything like that.
He's a very good judge, but the decision we're looking at here has zero to do with what he decided, right? We're looking at this completely as though it had never been decided before.
Fair.
Okay.
My question was, so, if you claim the release was from any claim that could have resulted from the accident, but as a matter of law, negligent hiring or retention, that's not derivative from an employee's negligence. So how can it be that it could have been released if it isn't related to that employee negligence?
So, Your Honor, this is partially where the concurrent versus excessive joint tortfeasors come in. It's funny that my opponent mentioned the two fires. That was a big argument that we had in my 1L tort class. The concurrent causes here, they're alleging that because we were negligent in hiring and retaining this delivery driver, he never would have been on the street and never would have caused this crash to occur in the first place. So they are concurrent rather than successive tortfeasors causing multiple injuries. And so because had Minsky's not allowed this delivery driver to continue to be a delivery driver, it's our contention that the plaintiff's allegations still arise out of the crash, even though arguably the actions which allowed the delivery driver to be a delivery driver occurred prior to the crash itself.
But isn't the question of causation inherently a factual question that would require a finder of fact to determine based on the evidence? That's not really what we have here. What we have here is a question as to whether this specific language included in the release specifically identifies Minsky, or whether we can look at the language and determine from looking at this release language that Minsky is also released.
That's correct, Your Honor. To jump over to the question about whether we've met our rebuttable presumption because it is a motion for judgment on the pleadings, it is our contention that the plain language of the release, the references in paragraph 1 and 4. And again, doesn't specifically state Minsky's, but it's our contention that the language is broad enough to encompass Minsky's. In 1 and 4 should be sufficient to overcome the rebuttable presumption.
But isn't that essentially what the Supreme Court, in moving away from just a flat bar rule and saying, look, you've got to have language, not just about all claims, but you have to have language from which you can determine that this particular claim by this particular person is being waived.
Your Honor, I think that's a fair interpretation of the Luther Court. It's our contention that in this case, under the language that we have here and considering how the release came about, that it was negotiated by plaintiff's counsel and executed by the plaintiff, that should be sufficient to overcome that rebuttable presumption, making this different from the Luther case.
Okay, and in the language that you believe overcomes the rebuttable presumption, and what that means is because Minsky's is not identified here, we presume they were not released, right? And then you have to overcome that presumption with this language.
Yes, Your Honor, my interpretation of the Luther case is that because it does not explicitly state, and we hereby release Minsky's pizza, there is a rebuttable presumption that Minsky's pizza is not released. And so we look to, is there any other language in the release of all claims that would otherwise identify Minsky's and would overcome that rebuttable presumption?
Okay, so we're looking for something that overcomes the idea that this does not release. We're assuming this does not release Minsky's. We're looking for something in here to overcome that assumption or presumption. And what I see here is a release of two people and an insurance company and a policy that's owned by those two people. And then their heirs, executors, and administrators. Are any of those people Minsky's?
No, Your Honor.
Okay, so in the released parties, Minsky's is not identified, and there's nothing in this language, because it could have said their employer, and that would have been maybe something, right? So there's not a word in the released parties that overcomes the presumption that they're not released.
In the list you're looking at in paragraph 1, you are correct. There is not a specific reference to Minsky's or to an employer.
But not even specific. I mean, I see nothing that can even be lightly associated with Minsky's. Right?
Okay. Your Honor, I understand your interpretation.
Well, I mean, tell me which ones. If you don't agree, tell me which ones. Because when I read your brief, it said this language overcomes the presumption and shows that Minsky's is released. And I'm saying that after drafting many general releases that were far more broad than this, I could have found lots of words in those probably. This has very few words as to the released parties. So none of them here refer in any way to Minsky's. And so then we would go to paragraph 4. If we're looking for other language related to Minsky's, is that the contention?
Yes, Your Honor. Okay. And that paragraph 1 releases any and all claims that the plaintiff otherwise could have had related to the accident. And in paragraph 4, he understands that the $100,000 which he received in compromise are made to terminate further controversy respecting all claims for damages that he heretofore asserted or that the plaintiff or his personal representatives might hereafter assert because of the accident.
And I understand that language pertains to the claims and the nature of the claims and claims that are related back to the accident. But how do you expand that? How do you expand the parties? How do you bring Minsky's into that language?
Your Honor, it would be, it's our understanding that that at the time this was entered into, that understanding Judge Hurst's contention that yes, there could have been many other parties that could have been sued. We could have sued the plaintiff, could have sued the bike manufacturer, the car manufacturer, but that the two main individuals or companies that could have been sued here were the defendant delivery driver and Minsky's. And that when the plaintiff negotiated this language and entered into it, it was understood that those were the only real two main defendants, that the plaintiff could have specifically excluded Minsky's and said in the last paragraph or in a separate paragraph, we hereby reserve any and all claims against Minsky's Pizza and no claims against Minsky's Pizza or any other party who is vicariously liable for the plaintiff or the defendant's actions shall be released, but they didn't. And I understand that doesn't add language to the release. It provides context for what we believe the release does say.
But isn't another part of the context the fact that this release was under the driver's personal policy, not a Minsky's policy?
That is certainly a factor to consider, Your Honor, yes.
Normally when we are thinking about presumptions and then overcoming a presumption, we say that the presumption, like certain language gives rise to a presumption, and then you can offer evidence that would undermine that presumption or demonstrate that a different outcome is proper. Here, would you agree that there is no other evidence? The entirety of the evidence before us is the release itself and then any other allegations that are in the pleadings.
That is correct, Your Honor. That this happened so early on, we didn't do any discovery in the case. The petition was filed, the answer was filed, the release was included in the answer as a pleading, and the motion for judgment on the pleadings was filed. So there is simply no other evidence to turn to.
Do you think there's a do you think there's a problem with trying to overcome a presumption at this stage of litigation? Like, do you think it's legally possible?
Your Honor, I do in this case. I'm sure the facts of every case are different, but in this case, I do think it is possible. I understand that the court is certainly able to disagree with me, and that's perfectly fine. But I do think that if we read paragraphs 1 and 4 in conjunction, we do get over the presumption.
Okay.
Thank you, Your Honors.
Any other questions? All right, thank you very much. Mr. Sternberg, you have 3 minutes.
Briefly, Your Honors, I think my opposing counsel has a hard job and did a good job with that hard job, but the argument he made that reading 1 and 4 in tandem is a specific identification fails for, I think, the reasons that the court had in the back and forth. He conceded that there is nothing that specifically mentions or even refers to remotely Minsky's in paragraph 1. And the language in paragraph 4 to which he's referring, I think everyone's ignoring, begins, I understand that the parties hereby released. It still is limited to this and said payments and settlements and compromise, meaning the ones that were before, which were not involving Minsky's. I want to point the court real briefly to public policy behind this. In Luther, the Supreme Court's point was grounded in comparative fault principles. A tortfeasor who hasn't taken part in the satisfaction of a plaintiff's claim shouldn't benefit from a settlement negotiated with somebody else. And that's—
Sorry, I don't want to cut you
Your
off,
Honor.
but I'm definitely
Please.
going to.
Please.
Can you address Mr. Wagner's actually quite good point of why wasn't Minsky's just really reserved?
My client is under no obligation to reserve them because the language of a release is construed the opposite way under the specific identity rule, which we presume that people follow the law in executing contracts, which this is. Under that rule, my client is under no obligation to release other people. He doesn't have to, as you said, they could sue the car manufacturer, they could sue the bicycle manufacturer, they could sue the city of Lenexa. Maybe there was a sign that was bad or something like that. They're under no obligation to imagine all of the possible tortfeasors there are. That's one of the reasons we have this specific identity rule in Kansas rather than some kind of a flat bar rule, is we want people to know exactly who they are releasing in claims. And if you don't release Minsky's, well, Minsky's isn't released. And that's the short answer for that. As far as the successor and concurrent thing, now that I think more about that, that's just a red herring. The question is whether this is an independent claim rather than a vicarious claim. A vicarious claim would have required them to sue both the employee and Minsky's. We didn't have to bring, and frankly, we aren't bringing at this point, a vicarious liability claim at all. And we wouldn't have to. If all we wanted to do, if you look at brought my computer up, but it already went away. Paragraphs 20 to 25 of the petition, record volume 1, page 5, it states all of our independent claims against Minsky's. We didn't have to sue the driver for that at all. These remain independent claims, just like, I forget which case suddenly in front of me, but the one about the newspaper, where you have a newspaper committing defamation and people who wrote for the newspaper, and getting rid of one doesn't get rid of the other, even though they happened at exactly the same time because they're independent. Your Honor should reverse.
Thank you.
Thank you.
Questions? This court will take the matter under advisement.